So it would seem that somebody did this thing where they try to get the bandwidth, and so I try to do something, and they take the first account, and the first account has got that 420 reference, which means they're dealing drugs. And what do I got? Well, I got the account where I gotta take a Jew, right? And I'm doing that right now. Bennett, you're mine. You defaulted. You and that little game that those hustlers at the Supreme Court of Texas, they set up, it defaulted. And it defaults to me. So I'm taking it today. I submitted a closeout report to Robert S. Bennett regarding a November 16, 2016 outline for a proposed response to disbarment of attorney Robert S. Bennett. If I am correct, it is dated for October 7th of 2019. Today is July 7th, 2021. It's 1:57 p.m. I am in Dallas, Texas. I'm going to read this just so you have an understanding of what we're working with here. It was originally composed and finalized by 2:40 p.m., but then I went ahead and proofread it. It has had a hack since then. There are strategically placed typos in this, but I'm going to read it as is. The following is a submission of follow-up to the points offered for consideration as part of the agreement between Robert Bennett and Charity Kraus, aka Charity Colleen Kraus, that was agreed to per submission of outline and compensation per invoice. This work was officially performed between November 2016 and February 2017. In February 2017, Kraus terminated her professional relationship with Bennett for reasons outlined in an email to him in February 2017. Additional factors, however, compel a formal closeout with this report. Addressing first course. A. Concerns regarding Judge Carmen Kelsey's fitness need to be evaluated based on A. The willingness of the Supreme Court of Texas to permit public posting of a fraudulent court transcript on a publicly available website while the appeal proceeding was in process. And B. The refusal of other judges to address intentional manipulation of other cases during the process of Bennett's appeal of his disbarment and other proceedings over 2 years. B. Contract terms need to be evaluated. A. Based on the Texas Constitution, specifically the Texas Constitution mandates that all other laws in Texas are subordinate to the Bill of Rights. B. Within the context of the Texas legislative, executive, and judicial branches permitting unconstitutional amendments to be put before voters in the last 2 election cycles. C. Within the context of the aforementioned entities permitting further unconstitutional amendments to be put on the upcoming November ballot. And D. Within the context of the fact that numerous unconstitutional and fiscally unsound laws were passed by the Texas legislature, signed by the Texas executive, and allowed to be put into effect without any challenge from the judiciary, including per a lack of initiative on the part of the acknowledged Attorney General of Texas to bring such a case before the court. C. Concerns regarding authority need to be evaluated in the context of the rules of the 1836 Constitutional Convention and whether or not such authority is legal and constitutional under the provisions of the Texas Constitution itself. D. Contextualizations of disbarment proceedings need to be based on processes of qualification for membership in the bar itself. See February 2017 outline regarding questions concerning the State Bar of Texas for reference. E. Standards of behavior concerning the treatment of lawyers need to be evaluated relative to the responsibility an attorney takes on with respect to his or her relationship with a client and in consideration of the lawyer's capacity to represent the client's needs in conjunction with the lawyer's duty to uphold the law. Appropriate context for consideration is not law to lawyer as much as lawyer to client. Lawyer to lawyer, not lawyer to client. Questions of jurisdiction need to be addressed as a matter of jurisprudential integrity, as well as in consideration of potential manipulation as an abuse of power. Addressing second course. Considerations of prosecutorial misconduct are not the same as denial of rights to due process and habeas corpus for the purposes of political opportunism and economic and other forms of exploitation. This compels consideration of the importance of A. Providing support to people exercising their legal rights to represent themselves pro se. B. Protecting against abuses of any lawyer's insurance programs or other forms of financial support a member of a bar association receives to proceed with a legal case versus a person representing themselves pro se. C. Protecting against and prosecuting for acts of fraud engaged via abuse of the court filing process, including violations of rules of evidence concerning electronic filing. And D. Securities fraud engaged in relation to the use of client data in the stead of representing the best interest of the individual client. This is a closeout report. I understand that it is a compelled performance in the course of ongoing securities fraud and is demonstrative of a bad faith effort to engage the original contract. This was composed and finalized on October 7, 2019. I haven't read it in a while. There have been numerous typos that have been hacked into this actual, which would be official version of the report I had. I made indications every time I identified somebody had hacked in to try to strategically change it. There are at least 3 typos in this version that were not in it the last time I read it, right? There might be some alteration of the time stamping. I have other electronic records in my backup storage that I can check, right? But the point here is that the whole situation with that contract was part of a farce that was intentionally engaged in order to engage acts of sedition. And people completely violated and abrogated their alleged government positions in order to create this ceremony that has had not only national but international security implications. I just found evidence that, if it is actually correct, reveals that, in fact, I was accurate when I said in November of 2019, the people of Texas had conspired with others to engage in illegal and illicit process of intentionally sabotaging their children's education and welfare with an anticipation they would swap it out with somebody else's children. How dare you? Everything else was a subordinate concern to assuring your children were protected. You don't have a right to say your children are to be made available for financial speculation, and you'll just drug them so nobody knows. And if anybody sees you drugging them, you'll just try to get them to deal drugs for you, up to and including what appears now to be a $1 billion securitization bond, which is absolutely friggin' fraudulent, as a way to try to cover up for those crimes. I don't think so. It's not going to happen. Unfortunately, the actions that instead were taken by the Supreme Court of Texas, as well as whoever thinks they're in a position to do some sort of internal controls against abuse of the judicial process and or actually hold accountable members of the executive or legislative branch, has failed miserably and has already been revealed, including in consideration of what was allowed to be acknowledged as an opinion by a former Attorney General of Texas that's now in the United States Senate, or at least alleges at the time he was the Attorney General, and alleges he's now operating as a senator in the United States Senate representing the state of Texas. You lack command. You don't have the authority. Everything you're doing is just charlatanry. And what it's doing is it's exposing the people of Texas to a harm that is completely unacceptable. You've had years to actually address this in accordance with what you say are your professional qualifications. I don't believe you ever had those qualifications to begin with. And if you did, you allowed for them to be bartered away for some ulterior motive that demonstrates that you are, in fact, the ones that had the bad faith effort. You had a bad faith effort to manipulate and disabuse what you wanted to pretend was your interpretation of the Constitution in order to deny other people their rights to due process by making yourself the exclusive means by which they could access. That is not acceptable. We are far beyond being able to cover up for this. If I am correct, somebody has again tried to engage some sort of process of ceremonially going back through the Texas annexation and trying to play out as if you let a bunch of slavers try to barter our lives away. Again, trying to flip more old-time Confederate pension funds, including in connection with 2 disappeared attorneys general. No. 150 years was enough time to clean up your act. You didn't do it. You're getting closed down. This is a legal nuclear disaster, and it is unsafe for anybody to play around like they are part of this or to allow for this to stand. This contract is over. It's canceled. The contract that you charlatans in Texas are trying to take out on the rest of the fucking world is canceled today. You bear full responsibility for the cost. You don't get to waive it off, and you don't get to try to make somebody else's clients pay your legal fees.